Ready? Exercise number 4. Start. As pointed out earlier, with reference to the decisions of this court, the state enjoys the widest latitude where measure of economic regulations are concerned. These measures for fiscal and economic regulation involve an evaluation of diverse and quite often conflicting economic criteria, adjustment and balancing of various conflicting social and economic values and interests. It is for the state to decide what economic and social policy it should pursue. It is settled law that in view of the inherent complexity of the fiscal adjustments, the courts give a large discretion to the legislature in the matter of its references of economic and social policies, and effectuate the chosen system in all possible and reasonable ways. If two or more methods of adjustment of an economic measure are available, the legislative preference in favor of one of them cannot be questioned on the ground of lack of legislative wisdom, or that the method adopted is not the best, or there are better ways of adjusting the competing interests and the claims, as the legislature possesses the greatest freedom in such areas. It is also well settled that lack of perfection in a legislative measure does not necessarily imply its constitutionality, as no economic measure has so far been discovered which is free from all discriminatory impact, and that in such a complex area in which no foolproof device exists, the court should be slow in imposing a strict and rigorous standard of scrutiny, by reason of which all local fiscal schemes may be subjected to criticism under the Equal Protection Clause. Having regard to these settled principles, the impugned judgment of the High Court could not be sustained. Stop. Next para. It may be noted that factually it is neither possible nor practicable to give the exact breakup of figures in regard to the expenses incurred under different heads and other departments of the government in relation to the administration of civil justice. Stop. Next para. In view of aforesaid enunciation of law in unequivocal terms, it is inexpedient to multiply the authority on this issue. Stop. Next para. The next question which requires consideration is as to whether the state has to satisfy with mathematical precision that the fee collected is spent for the purpose it has been levied. In the present case, therefore, one has to see as to whether court fee is levied is spent on administration of justice. Full stop. Thank you very much. Guys, there is one humble request. Please always try to repeat the matter so that your fluency and accuracy will improve. And also, please subscribe my channel for next audio. Thank you very much.